Thank you, and thanks for joining us today, and welcome to our third and final of a series of 3 webinars celebrating TLPI's 25th anniversary. The webinars have been entitled Celebrating the Journey, Honoring Our Relatives, and Building a Vision for the Future. This webinar focuses on the very final and third part of that series, Building a Vision for the Future. Please note that no federal funds are being used for this webinar. I mentioned a few minutes earlier, but will mention again, my name is Kelly Stoner. I'm a victim advocacy legal specialist with the Tribal Law and Policy Institute. And I'd like to introduce you to the Executive Director, Jerry Gardner, and he will be making some closing remarks at the end of the webinar. This webinar features a panel of tribal scholars and justice system practitioners that will dive into what a decolonized future might look like. The webinar includes topics such as compliance with the United Nations Declaration of Rights of Indigenous Peoples. You might hear the panelists refer to this as Undrip. Possible expansion of current limited tribal criminal jurisdictions over non-Indians under VAWA's Special Domestic Violence Criminal Jurisdiction. The panelists may refer to this topic as SDVCJ. Implementing meaningful restorative justice and building a decolonized tribal justice system focused on tribal values. I am pleased to introduce this distinguished panel joining us today. Our panelists include Lauren Van Schilfgaard of the Cachita Pueblo. She is the San Manuel Band of Mission Indians Director of the Tribal Legal Development Clinic at UCLA School of Law. She previously served as TLPI's Tribal Law Specialist, where she coordinated training and technical assistance to tribal courts, focusing primarily on tribal healing to wellness courts, restorative justice, tribal court infrastructure, and federal Indian law. At TLPI, Lauren worked with over 80 tribal nations on various legal infrastructure projects. Lauren is a widely respected presenter on numerous Indian country related topics and an ongoing consultant for TLPI. The next panelist is Pat Sikekwetua of Hopi. She is affiliated with the University of Fairbanks in its Department of Alaska Native Studies and Rural Development. Her academic research and teaching areas include rural and native economic and community development, tribal sovereignty and governance, and tribal courts and conflict transformation. She is also a nationally known presenter and trainer on tribal law, court development, and conflict resolution topics. She presently serves as a tribal judge, arbitrator, and mediator, and sits as a justice on Hopi Tribe's High Court in Arizona. She was a founding board member of the Tribal Law and Policy Institute and served a crucial role as TLPI's associate director in the late 1990s and early 2000s. She continues to serve as a TLPI consultant and is on TLPI's board of directors. Next, we have Sarah Deer of the Muskogee Nation. She is a University Distinguished Professor in Women, Gender, and Sexuality Studies in the School of Public Affairs and Administration at the University of Kansas. She is a Chief Justice for the Prairie Island Indian Community Court of Appeals. As a tribal jurist and scholar, Justice Deer's scholarship focuses on the intersection of federal Indian law and victims' rights using Indigenous principles as a framework. Sarah is a co-author of 4 textbooks on tribal law and is published in a wide variety of law journals. Sarah was named a MacArthur Foundation Fellow in 2014 and a Carnegie Fellow in 2020. Sarah was an early TLPI staff member, serving as TLPI's Tribal Victim Advocacy Legal Specialist from 2003 to 2009. Our 4th panelist today you'll hear from is Judge Abby Abenanti. She is the Chief Judge for the Yurok Tribal Court. Judge Abenanti is a graduate of Humboldt State College and of the University of New Mexico School of Law. When Judge was admitted to the California State Bar in 1974, she was the first California native admitted to the California State Bar. In addition to serving as a chief judge at Yurok since her appointment in March 2007, Judge Abby served for 18 years as a California Superior Court Commissioner for the City and County of San Francisco, and she was assigned to the Unified Family Court. She retired from that position in 2011. Judge Abenanti has served as the president of the Board of Directors on the Tribal Law and Policy Institute since its establishment in 1996. And by the way, happy birthday, Judge Abenanti. Our first panelist that you will be hearing from today is Lauren Van Schilfgaard. Lauren, I'll turn it over to you.
Thank you, Kelly. It is such an honor to be on this panel with such esteemed panelists, including my former colleagues, my current colleagues, my mentors, my former professors. It's really, really an honor to be here. As Kelly mentioned, I am Lauren Van Schilfgaard. I am a member of Coche de Pueblo. I am calling from my virtual fantasy office that has a Santa Fe background, but I'm calling from Burbank, California, which are the traditional homelands of the Tongva, the Tataviam, and the Chumash. As Kelly mentioned, I am currently the Tribal Legal Development Clinic Director at the UCLA School of Law, where I have the privilege of occupying the seat that Pat Sikakwatu formerly occupied. I get to work with law students on tribal projects around the country, as well as here in California, which is an incredible honor. I previously was at TLPI, which is hard to overstate how formative and incredible that experience was and continues to be. I'd like to share my sincere congratulations to the Tribal Law and Policy Institute on your 25th anniversary. You have completely transformed tribal justice systems. You contribute in such meaningful ways, and I'm really excited to see how you continue to do that work for the next 25 years. It's such an honor to see all of the incredible attendees here today. Thank you so much for joining us. So our call today is to envision building a vision for the future. And so I'm attempting to help set the stage so my panelists can really take it away with their incredible visions. When considering what a future for tribal justice systems can look like, for tribes can look like, at least I feel compelled to contend with the colonial foundation on which tribes have been compelled to build their current tribal justice systems. It feels, a lot of my work at TLPI and working with tribes are the epitome of resilience, right? We are continually building and preserving our systems for the future. But in so many ways, in so many very formative ways, this has been in spite of and in the face of federal systems that have either sought to explicitly exterminate tribes or at least mold in a very certain way to eventually assimilate tribes into the greater polity. Tribes are operating in systems that are designed to eventually delete tribes. This is problematic for all sorts of reasons. And so a term that has been thrown around a lot is a call to decolonize. Decolonize federal Indian law, decolonize tribes, decolonize this, decolonize that. I think are going to attempt to break down that term and understand it in order to help inform what we think a future can and should look like for tribal justice systems. So I'm only slowly coming to appreciate the ins and outs of this, in part because I realize much of my education has been colonized. But my take is that from the moment of contact, the legal position that tribes have occupied in relation to the rest of the world has been under the thumb, right? The famous doctrine of discovery is essentially legal shenanigans to place tribes, tribal people, indigenous people in a second-tier status, in that case in relation to property rights. And you see this ripple out that there's the moment that Europeans arrived into the Americas, there were lots of colonial projects going on, including legal colonial projects that have informed what we now understand to be federal Indian law. Federal Indian law is the federal government's laws in relation to indigenous people, and is really about how we're going to have a colonial type relationship, a guardian, a paternalistic father type figure over an inferior status, a childlike status, a ward status. This has been used against tribes over and over again. We see, the 19th century, which, I think a lot of people assign to a long time ago, and yet those policies absolutely inform what we currently operate now in the 21st century. A lot of that were explicit extermination policies, but they also were rooted in a nation-to-nation type relationship. We had treaty making, we had negotiations, essentially really fancy land transfer agreements. They were coercive, they were unfair and tilted, and yet the idea was that tribes possess this inherent sovereignty that is comparable to the sovereignty enjoyed by the British Crown and later the United States government. However, and here's where the rub is, and here's where I think the decolonization work really begins, is the plenary power, the unilateral fist that the United States government pulls out when convenient in relation to the nation-to-nation government with tribes. There are numerous examples of this, but only some of them include 1871, when the United States abruptly decided that they would no longer engage in treaty making with tribes. With termination, the idea that the US government has a formal relationship with tribes up until the moment they decide that they don't want to anymore. With the doctrine that the US government can unilaterally abrogate treaties, disestablish reservations. Essentially, it is an unfair and a faux negotiation when one party has all of the power to make determinations without the input of the other party, and certainly without their consent. This includes the ability to recognize the mere existence of tribes. At the end of the day, these are all legal considerations and truly pale in comparison to the simultaneous physical extermination that was taking place then and in many ways continues to take place now, the cultural genocide, the forcible removal of children from their homes, the explicit intentions to eradicate languages and culture, all for the purposes of obtaining more land with less resistance. These are incredibly troubling and today rise to the level of what we now consider to be human rights violations. So it's on this bedrock that tribes and their government systems exist. Tribal justice systems exist within the United States because they are tolerated by the US government. This is most explicitly evidenced in the 1934 Indian Reorganization Act, which recognizes tribes to operate their own governments. But critically, the ways in which the US recognizes tribal self-governance is in the US government's own image, right? Tribes were encouraged and continue to be encouraged to organize governments that look, smell, feel like US government systems, namely municipal governments. This is the same for tribal courts. We see this throughout the 20th century and certainly through the 21st century up to date, that tribal courts are tolerated, kind of, and certainly only in the ways in which tribes have been willing to adopt adversarial systems that look a lot like US courts and state courts. It's up for debate, and some of my co-panelists will engage in this debate about the extent to which this may be appropriate for tribes to encourage. But the critical point here is that self-determination, self-governance means that those conversations are happening within the tribe. But under federal Indian law, that is not the dynamic. Rather, the US government is dictating to tribes how their tribal courts should look like. We see this in the Indian Civil Rights Act of 1968. We see this reinforced in the Tribal Law and Order Act of 2010 through the enhanced sentencing provisions. And we see it doubled down in the VAWA amendments of the Reauthorization Act of 2013 regarding special domestic violence criminal jurisdiction. The US government is using tribal jurisdiction as a hostage and will only deal out little tidbits on the condition that tribes are willing to further assimilate their justice systems to match what the US government considers to be fair and just. That is the epitome of a colonial dynamic and is what international forums are now calling out as a antiquated human rights violation type system. That control, that thumb, the use of legal jargons like the doctrine of discovery is no longer considered permissible. This is reflected in what Kelly referenced as the UN Declaration on the Rights of Indigenous People. So the United Nations is an international body. Notably, it is still rooted in the same sort of colonial mindset in the sense that it uplifts and recognizes the nation state as the forum with which international communities can interact. And so even in this declaration that recognizes Indigenous rights, it's through the lens of Indigenous people that live within a nation state and are occupied by it. Indigenous people do not have the opportunity to join the UN as a separate entity. It is only through the nation state. Nevertheless, this document was a completely game-changing document. For the first time, an international body recognized rights that were distinct from rights based on the individual. Very central in US doctrine is the central role of the individual person. All of our conception of rights are rooted in an individual in opposition to the nation state. This UN declaration, however, recognizes a different set of rights, Indigenous rights, collective rights. This is incredible. The document is aspirational. Nation states signed onto it, including the United States, albeit belatedly. And the idea is that, yes, we think that these are good ideas. The UN declaration, however, is not binding. It only becomes law once the nation states make it law, because in the world order as it is today, nation states are where the buck stops. Until a nation state domesticates those laws, or for example, puts forth a bill in Congress that is enacted, only then are those rights binding under US law. We have some baby movement towards then, but it's also true that tribes have sovereignty, even limited under federal Indian law. And more importantly, they are governments over their own people. They too have obligations to ensure both the protection of individual rights as well as collective rights. So when we talk about the need to decolonize federal Indian law, including as it constrains tribal justice systems, we can look to the Declaration as a framework for guidance on how to do this. Some of the critical components that the Declaration puts forth include a vision of how Indigenous people should relate to other entities, including the colonial government in which they reside. This includes a relationship rooted in free, prior, and informed consent. This is notably different than our current consultation model, which even if its best form is still rudimentary, I would say, as upholding Indigenous rights. Most critically, and I think most relevant for tribal justice systems, is the Declaration's emphasis on self-determination. Tribes need the ability to develop their own systems that reflect both their traditional customs and traditions, but also their vision for their own future in the 21st century and beyond. This must include the right to territorial jurisdiction, a release from all of these jurisdictional limitations, as well as a release from all of these conditions. Even if they might be a good idea, tribes need the opportunity to decide for themselves the relationship that they as a government have with their own people, as well as with their other neighbors that may not be citizens of the tribal nation. How tribes envision themselves as a sovereign entity, and whether or not that reflects an international norm of a nation state framework, can and should be up to tribes. And we would purport that the Declaration is an opportunity to help articulate that, both externally with other entities, but critically internally for how tribal self-governance can and should be. I am elated to help dive into more about what this means for the tribal justice system by turning it over to my fellow panelist and my former professor, Pat Sika-Kwapua.
So, hello, everybody. And let's see if I can get my, let me just do a check with the text. Is my video coming through?
Yes, you look great.
Okay, great. For some reason, I see Lauren. So thank you so much. I'm overjoyed to have been invited to think about the future and our tribal justice systems. And I'm really kind of shocked that it's been 25 years since we started the Tribal Law and Policy Institute. My sense of things is that we've hired a lot of really smart, younger Native attorneys and staff members, and that they're kind of blowing the old fogies out of the water. And I'm just, I'm in awe also of the work Lauren is doing, from her work at TLPI now to working in the Tribal Legal Development Clinic at UCLA, and all of her work with the Undrip as well. So what I'd like to do is sort of talk about my experience with exposure to this decolonization stuff and Undrip. As I mentioned, I definitely come from an older generation of both Native scholars, tribal judges, and I guess just Native activists. We come from the tribal sovereignty approach, right? So we got really used to using the tools of US federal recognition, tribal sovereignty, tribal jurisdiction. The Hopi court system, for example, has been in operation using an adversarial process for nearly 50 years. And that's kind of mind-blowing to me. We've taken these tools and we've made them our own. I always say we're doing Hopi things using these Western tools, talking about Hopi stuff for Hopi purposes. And this is it's important to us in our community. So the big question here is, what does it mean to seriously envision decolonizing tribal justice systems? Those of us from the older generation might say, isn't that just going to undo all the hard work that we've done in our own self-determining and our own customizing of our own systems? So I'd like to preface this conversation by saying, I'm thinking about decolonization and the Undrip from an internal perspective. How do we talk about this within our individual tribal systems and also among our US federally recognized tribal systems and tribal court systems? And I think part of that work is going to involve constructive criticism, because there are going to be some difficult conversations to have that facilitate different positions, different interests and concerns and priorities, even within our tribes and our tribal court systems. Okay, next slide, please. So where does this decolonization stuff come from? It comes from Native academics, Indigenous academics, particularly those who were working in the social sciences or were trained up in the Western social sciences. And the outstanding scholar is a Maori woman named Linda Tuhiwai Smith. And she wrote a book way back when called Decolonizing Methodologies, which is now in its 2021 edition. So she's talking a lot about Western social sciencey research here, but as I read this, you just substitute the word law, legal methodology, and legal research and see what you think. So she says, one of the problems discussed is that the methodologies and methods of research, you read law here, the theories that inform them, the questions which they generate, and the writing styles they employ all become significant acts which need to be considered carefully and critically before being applied. In other words, they need to be decolonized. So she's saying, look at the institutions, your Western adversarial institutions that you've built in your tribal communities. Look at the legal processes you use. Maybe we're talking about due process. Look at the standards that you're using in your Western adversarial process. Does this need to be decolonized? However, she says, decolonization does not mean and has not meant a total rejection of all theory or research or Western knowledge. Rather, it is about centering our concerns and worldviews and then coming to know and understand theory and research from our own perspectives and for our own purposes. So I do think she leaves a possibility here that, for example, at Hopi, we're using a Western adversarial process for our own priorities, for our own purposes. Nevertheless, she would always say, I think, that we need to go back and look at the extent to which that colonial process or that influenced Western adversarial process maybe is not doing what we want it to be doing. Okay, let's go to the next slide. So the how of this, right? The devil is always in the details. So in my mind, this is about the Undrip. It's taking the bits and pieces of the consensus that was reached by Indigenous people over the last few decades internationally and looking at how what they are suggesting might be used as a tool to at least reflect on our colonial influences in our tribal court systems. So the Undrip has, I'm going to say a gazillion articles, and Lauren can tell you exactly how many. But I went through and just cherry picked out the ones that apply to tribal courts, or at least would apply to my Hopi system. And I'm thinking about the Hopi tribal courts and the work I've done with it as I do this. So I came up with 5 that were that really jumped out at me as sort of imperative to think about. The first one is Article 1. Now, many of us who are Native or Indigenous and who come to the Undrip, we think it's all about collective rights, meaning the rights of the tribe or the whole Native community. But if you look at Article 1, you see pretty quickly that the Undrip is stating that Indigenous peoples have the right, both as a collective or as individuals, of all human rights and fundamental freedoms. So it's both looking at a preservation or protection of individual rights and collective rights. But it's not holding them up to the Indian Civil Rights Act here. It's holding them up to the Charter of the United Nations, the Universal Declaration of Human Rights, and international human rights law. So right there, there's a big difference. And my point with Article 1 is just, look, it's both individual and collective rights. Article 4 reinforces the right to self-determination and the right to autonomy or self-government in matters relating to internal and local affairs. That sounds familiar in federal Indian law. Article 7 focuses on, and here I'm focusing on the individual bits here, right? Because I'm thinking about due process and the Indian Civil Rights Act. Article 7 says Indigenous individuals have rights to life and liberty, but it includes other things like physical and mental integrity and security of the person. As a judge, that causes me to think, oh, well, we're also going to be requiring positive rights, that tribes support and enforce positive rights for people, like the right to healthy mental health care, for example, things that you have to put dollar signs behind as a government. And then Article 34 popped out as the right to promote, develop, and maintain institutional structures and their distinctive customs, spirituality, traditions, procedures, and practices. And here they include juridical systems, which to me sounds like tribal courts, or customs, which is interesting that that's an or, because I would say our Western adversarial Hopi court system also includes custom. That's and. But they would require this in accordance with international human rights standards. And then finally, Article 44 is the equality principle in the Undrip. All the rights and freedoms recognized are equally guaranteed to male and female individuals. Okay, so let me just point out some of the inherent conflicts within the Undrip that would cause some stir in Hopi. The first is that it definitely recognizes both individual and collective rights. And there will be a tension here as to which rights get enforced primarily. Are you going to enforce the rights for an individual over those of the collective, or the collective over the individual? Then the example that jumped out here for me are juvenile healing to wellness courts, right? Because we funnel a lot of youth into our tribal healing to wellness courts, and we require them to participate in customary activities or cultural or native activities. And I thought to myself, there's sort of two bits here. One is, do they have individual rights protections or due process rights? Do they have a choice in participating in these things, or do they have to participate in these things? And that would be an example of the collective. There's sort of a collective choice to expose all of our youth to the cultural and traditional systems. But what if we have some Christian youth in there who don't want to be a part of that? And do they have enforceable rights under our tribal systems? The second area of conflict I'm seeing is the straight up, is the equality between men and women. And so in our tribal systems, are we going to be concerned about protecting straight up equality between men and women? Or are we going to be looking at the duties and obligations that are different for men and women under custom and tradition? So for example, at Hopi, women in a clan have certain preferred property rights over men. And men are not going to be found to have sort of a trumping property right. Now, that's going to violate Article 44 under the Undrip, under most people's approaches, I would think. And so that's an inherent conflict that we would have to reconcile internally in the Hopi tribal court system. And by the way, we're doing that under the ICRA anyway. The third area of conflict is that even under the Undrip, there is still an external Western fairness test. And in our US system, that's the Indian Civil Rights Act. In the Undrip, in the international system, it's the Universal Declaration of Human Rights, which assumes or presumes, or there has been a consensus that there is a set of fundamental human rights. And we've seen some of them here in the articles. Okay, so let's jump ahead a slide. Okay, so I wanted to talk a little bit about the toolkit that UCLA and the University of Colorado and NARF has put out in supporting tribal implementation of the Undrip provisions. So in the toolkit, and there should be a link in your, probably in the chat here shortly, to the toolkit, there is a sample bit of resolution if a tribe wished to adopt it, called the Tribal Wholesale Implementation Act. And this draft resolution would permit a tribal council, not permit, it would facilitate a tribal council doing a wholesale adoption of the Undrip provisions under tribal law, under binding tribal law. And under Section 4, for example, the tribal government shall take all measures necessary to ensure that the laws of the tribe are consistent with the Undrip. All measures necessary. So that would be things like constitutional reform of the tribal constitution, statutory reform of your codes. It would require judges in the tribal court system to do a case by case. In litigation, they'd be looking at how the Undrip was relevant to that particular conflict case by case. They'd issue judicial opinions talking about it, and they'd say what the law, how the law should be applied and what it means in that tribal court system consistent with the Undrip. And if certain tribal laws were not consistent, then they would say, well, you have to either interpret it to be consistent or you toss out the tribal law as not being consistent. I suppose there's questions about whether or not you should implement the Undrip through your tribal constitution instead of through a separate resolution or ordinance or statute. And those are big considerations. Okay, let's take a look at the next slide. So this is a picture from our Hopi tribal courts in Arizona. And as you can see, they're very Western style, the black robes, adversarial process, attorneys representing the different parties. We've been doing this for a really long time. And we do need a certain amount of sort of Western process because at Hopi, we're made up of two different culture groups, the Tewas and the Hopis, different languages, different ceremonials, and we also have 12 villages, and each village has a different grouping of clans inside of it. And clans are very secretive and protective about their clan customs. So no one Hopi judge would be able to would be able to say what the custom is for others. So we have to have a certain amount of process where we don't share knowledge and value systems across the entire reservation. And of course, I've already mentioned that men and women have different duties and responsibilities under the clan system. And that can look like different rights for men and women. All right, let's jump ahead to the next slide. Next slide, please. I'm going to jump ahead because my time is a little bit short. We'll go forward one more. So I've been working up in Alaska for the last 7 years, and it's interesting to me, what would it mean for Alaska Native justice systems to decolonize? They're not even starting where Hopi started. They're starting more recently, and a lot of them want to launch straight into restorative justice practices and avoid adversarial process altogether. They want to use circle process for most of their cases. Now, I don't want to generalize across all Alaska tribes. There are some that want to do it differently, and that's their choice. However, it is an interesting question to ask. So they want to start out restorative and then add just little bits of fair process, maybe, you know, the bare necessity of due process that they can to supplement their restorative process. And so that's an interesting modeling challenge for TLPI to see how to structure that kind of tribal court system. And this is kind of the cutting edge, what they're doing up here. I give credit to Tanana Chiefs Conference for starting this process, and also to Rural Cap up here that is exploring this further with also TLPI. Okay, let's go to the next slide. I'm not even going to do this one today because I think we're a little bit short on time, but the gist of it is there is a very complicated system up here in Alaska. You know, we have tribal entities and native corporate entities that sit side by side, sometimes work together, sometimes don't. And so you can do self-determination up here through a corporate structure, as well as tribal governments are doing it through their federally recognized structure. There's a whole nother level of colonization going on up here on the business side. And so there's a lot, you could write a PhD dissertation on this. Okay, let's go to the next slide. Okay, some of my personal observations here. There is a lot of internal work for tribes to do, and for federally recognized tribes to think through together about the Undrip, if that's the way we go, and if there is an urge to do some of this decolonial work. This is important but controversial and delicate work. The Undrip articles may be used to start the conversation. They are appealing in that they have a broader vision of what sovereignty means and what self-determination can mean for Native nations than under the constraints of US federal Indian law. However, even under the Undrip, there is conflict between individual and collective rights and which gets protected over which inside a tribal court system. Each Native nation will need to find and set the balance between the two within its own laws and justice system. Also, I think work needs to be done to understand the difference between the ICRA provisions and the Universal Declaration of Human Rights and international human rights law. We also need to understand the implications and principles of intergovernmental comity, full faith and credit, US federal court review of petitions for writs of habeas corpus. The gist is, in our US system, if we decolonize too much, are they going to not recognize our sovereignty or our jurisdiction or uphold our decisions? And I think each Native nation has to strategize accordingly here, make law changes as they see fit, strike the balance where they see it, and then lobby for any needed federal or state law changes. Okay, that was a lot. I'm going to leave it there. Thank you so much for listening, and I'm going to turn it over to Sarah.
Hi, everyone. Am I being heard and seen okay?
Yes.
Okay, wonderful. Well, first of all, I just want to thank TLPI for a lot, but particularly for inviting me to this event. I only worked for TLPI for about 6 or 7 years, but as most of you know, once you're part of the TLPI family, Jerry doesn't let you go. So it's funny because I haven't been a full-time employee since around 2008, I think. But when I talk about TLPI, I still say we. This is what we did, or this is what we worked on. And you know, and I think this is the first time I've had an opportunity to do an event with TLPI that doesn't have federal dollars attached to it. So my self-censoring for federal grant folks is very, very liberating right now. I wanted to talk about victims of crime today and the efforts to revitalize traditional forms of dispute resolution or create new ones. And I think the challenge that we're facing right now, we're currently in a sort of a national dialogue about race and policing and about the heavy-handedness of prosecutions on men of color in particular. And so tribes are not immune to this conversation, right? Are jails the way we want to go? Many tribes operate jails, but many are understaffed and underfunded. And certainly, I think most folks can agree that in cases involving, you know, nonviolent issues like child custody, substance abuse, and things like that, you know, it certainly makes much more sense to provide the particular person in question with healing opportunities and with restorative principles. I think where it becomes really difficult is when we start talking about violent crime. And by that, I mean homicide, I mean child sexual abuse, rape, and domestic violence. And there has been pushback both in the mainstream, you know, conversation about this, as well as the tribal perception of this. How can we ensure victim safety? If we can't ensure victim safety, then what do we really have to offer, right? Because that's what's happening. We have the highest rape rate in the world, the highest domestic violence rate in the world. We need to find a way to address that without depending on the state or federal governments, because they simply just don't do anything for us. And while there have been over the years some really important assistant US attorneys that have tried to turn the tide, we still see the numbers of federal prosecution extremely low, right? And so the question is, do we adopt, and many of us have, adopt a Western law and order system to respond to violent crime? And many tribes only really prosecute misdemeanors, although they have the inherent authority to prosecute all crimes. So one of the things that I, after my first book was written, The Beginning and End of Rape, I had a lot of folks asking me, okay, so now what? What do we do now if the Western law and order system isn't working? And wanted an answer, a replacement for the old, you know, the sort of copycat cut and paste version of doing criminal law. And so, and then what do the victims want? Well, how can we support victims? And so I decided to launch a new empirical study. It's my first empirical study. We don't really learn those skills in law school, so I've had a lot of support along the way. But I've talked to over 50 Native women and Two-Spirit people who have survived sexual assault. And it's an IRB approved study. I did recruitment over social media at the last TLPI Indian Nations Conference and other ways of reaching out to folks, and ended up with a core of 50 people who identify as Indigenous and identify as survivor. And I interviewed each of them for sometimes 20 minutes and sometimes 2.5 hours, depending on the particular question or the particular participant. I did have a guiding questionnaire with the interview questions, but it was left very open-ended so that folks could share what they want. I'm still in the process of transcribing and coding those interviews. And I did provide nominal compensation for those who did participate. So what that means is I'm trying to sort of dig into these interviews and find out, okay, so if we're going to keep victims safe, let's ask them what they want. And certainly for a lot of them that were victims of serial offenders or repeated assaults over time, tend to talk about incarceration as a way of making them feel safe in the community. On the other end of the spectrum are folks that say, hey, my perpetrator went to jail and he came back worse than he went in, right? And so for me, that didn't work, right? That just made everything even more complicated and my safety was at risk. So I'm really interested, and it's still really too, I think, preliminary to really share the outcome of the study, but it will be a monograph published, a book published with the findings of the study. And I think it's a really important thing to keep in mind because safety is really the core of being able to be in a community and contribute to the community. So one of the things, of course, then is when we look at the Violence Against Women and the Tribal Law and Order Act and the language around, adversarial punishment, as it were, and certainly an expectation that tribes want this, that tribes want the dollar amounts, they want the fixes so that they can expand a carceral system. And I think it's up to each individual tribal community to make that decision. Do we want to use incarceration for certain kinds of crimes, or do we want to try something altogether new? And that's where I think victims' voices sometimes get lost. Because we're talking about, let's get the feds off our back, let's do our own thing. But sometimes victims are not part of that conversation. And that's what I hope to fill that gap with the study that I'm currently doing. Another challenge I think we have with the idea of doing non-adversarial restorative justice types of programs is how do we deal with non-Indians in that context? So for example, in the Violence Against Women Act of 2013, we got that mini Oliphant fix that says to certain tribes or says to all tribes, if you want to, you can prosecute non-Indians for domestic violence crimes. Now, the new version of VAWA expands that to include sexual abuse, assault on a police officer, and a few other things that it would allow tribes to prosecute non-Indians. So I think one of the biggest challenges, again, keeping the victims' voices in mind, is if we have a non-Indian who's on a reservation, married to a Native person, having babies with Native people, and they commit acts of violence against their family. And the restorative system that's been set up, or has always been there, is designed to be a non-adversarial process. And if the non-Indian who's committing the violent crimes is not familiar with the customs or isn't familiar with the ceremonial aspects of some judicial systems, are they getting due process then, right? So we want jurisdiction, or a lot of us want jurisdiction over non-Indians who do bad things on our reservations and in our tribal communities. But if they're non-Indian perpetrators, is that really a place for them? Are they invited into that circle? And is it appropriate to engage them with things that are none of their business, like ceremonial clan expectations and the like? And so I think it's a really difficult quandary that tribes find themselves in, especially in the national conversation on mass incarceration and the carceral state's failure to truly address the violence that happens in all of our communities in the United States. The last thing I just wanted to mention was this McGirt decision that came out in July of 2020, which recognized that the Treaty of 1866 that the Creek Nation signed with the United States is still in force. It has not been disestablished. And so the reservation and the other reservations in Oklahoma are also being re-recognized for having that territorial jurisdiction that we never relinquished. The problem we're up against right now is oil and gas companies funding hundreds of thousands of dollars into think tanks and to politicians to speak out against McGirt. And they're really concerned about the dollar amount, but they're using criminal justice as a way to critique McGirt. So they're not saying, oh, we're concerned that we won't be able to, drill for oil on the reservation. They're saying, oh, look, Native people are not being protected because there's these gaps in jurisdiction and that kind of thing. And so it's really an onslaught. I mean, they're throwing many hundreds of thousands of dollars on their PR campaign to overturn McGirt and or limit its holding. And so we are up against a lot of money, a lot of oil money in Oklahoma. And I know that's not unique to Oklahoma, but the public relations campaign has been devastating. And because we don't have hundreds of thousands of dollars to launch our own PR campaign, it's been difficult to engage at that level. I am concerned about the future of McGirt, but I'm going to try to stay positive for the future and hope that more territorial jurisdiction is returned to tribes across the nation who never relinquished that authority. So thanks again, TLPI, for having me here. It's been a real exciting to do something with TLPI again. And I will turn it over to our last panelist, Judge Abby.
Ayukwi. Nek now Judge Abby, Rekwoi Ak. What I said was hello. My name is Judge Abby and I live at Requa, which is in my home. And I've sat here listening and I am always transfixed and impressed by how young and bright all of the people who are working in this field are, and I'm feeling old and tired. What I can give you today in terms of vision is that a phrase from Yurok prayers. It's a fairly common phrase. And what it says is essentially, that's the translation is, Creator, please remember and please help, because we are only humans. And that gives you a sense of where you belong in the world. You're not at the top of the heap. You're in the world, and you have interrelated responsibilities to your world and to each other and to the community that you come from. And I don't know whether I undrip or drip. I guess it just depends on where I am in a particular situation. But I do know that these people came here, there was an invasion, and in a very short period of time, they have really junked the place up and made a lot of mistakes and hurt a lot of people. And one of the things that we as a tribe have learned, and what I'll say is that we're the largest surviving tribe in the state of California, and we survived a lot because we ran and hid. And right now, when people are talking about what kinds of systems do you need, I think we need to come out again and recreate our systems. Not recreate as in go back the 250 years, but go back to the value system and create practices for today and for today's problems. Because the practices they have created have frankly just about wrecked the joint. And if we don't come out and help ourselves and them, they will wreck the joint and they will take us with them. All of the talk, all of this and whatever, that's what we have to look to. We have to look to our values and develop practices that are different. You know, and when people say, okay, well, is it going to be restorative justice or this or that? And I go, beats me. I don't know very much about that. I know what Yuroks used to do. And I know that living in harmony was really important. And to the point that was made by, I said I was going to call her professor, by Sarah. I think, you know, we have to make choices about how we're gonna move forward and what rights we're gonna give. And Pat said things about this also, you know, because often now in our court, you know, the courtroom looks like our old houses look in terms of there's tables and we just sit around and we come to a place where we discuss it. You get to choose which system you want to be in. And many of the people just choose, I'd rather talk to you and see if we can fix this, or tell you what happened, and then come to, okay, let's apportion who's responsible for what and how we're going to fix this so we can go forward together as a community and as human beings and meet our responsibilities. And it's a much different discussion when you start talking about interlocking responsibilities as opposed to rights systems. And I think that the practices that come out of those change how you approach resolving what we do as humans. Now, humans are difficult animals. We're very prone to mistakes. We make a lot of them. So we need to figure out how we're going to work with them, what we're going to do, how we're going to move to tomorrow and deal with yesterday. You know, and you need to look at that and you go, okay, you know, I went to law school. I wasn't very good at it, as one might well imagine. But I did learn from being on the state court bench that this system that they have set up is very harsh and very cruel and does not look at the people that come before them. I spent a lot of time on the bench. I understood what my role was, and I was actually fairly decent at it. But then it come to a point and you go, you know, this isn't really right for them or what I should be doing. And when it was time for me to come home, I was not interested in setting up a similar system. It wasn't working for them. When we got caught up in it, it didn't work for us, and we need something different. And as far as the vision, that's what you have to get back into, is thinking about what would we have evolved to. We would not be the same whether they came or didn't come, because we change, because humans do. So what would we have changed to? And now there's so many more difficulties and so much discussion about this law versus that law, or this approach versus that approach. But we really have to stay steady in what we know to be right and what our value systems know to be right, and develop practices from there and go, you know, even as a judge or a system, that seemed like a really good idea at the time, but wow, was that a mistake to do it differently? Let's figure out how we're going to do it differently and consistently with the place and the environment and the people that we are, you know, and the people who came here also need some help, because like I said, we're responsible not just to each other, but to place. And when you have that added responsibility, you have to step up, and you have to step up in a way that's consistent with that responsibility. And that's, you know, as you envision how you're going to move forward, I think it's really important to look at that, to go, okay, how is this going to work? And also look at the practice that you were taught, you know, and go, you know, maybe this is not a really good idea. I don't have to sit up above everybody I grew up with and wear a black robe. I mean, I really don't have to do that. You know, I don't have to go, okay, you know, are you going to be telling me the truth or not? You know, it's really on you. And you tell me, and then we'll figure out. My job is to help you if you make a mistake, like people helped me when I made mistakes. You know, if I had a list of mistakes, I mean, this panel will go on for a really long time. So I won't go there for you, which I'm sure you will appreciate. But I have done a lot of them, you know, and that's where you have to move forward and what you have to demonstrate. And perhaps the one thing, if I look cross-culturally at all of us, all the different tribes, you know, yes, did we do things we shouldn't have? Yes, we did. But we had certain standards of kindness and community. And those have to come back to the forefront. You know, we have to be responsible in community and responsible to each other. And that's my vision of how to set up the system and to move forward. You know, and you can look about and you can say, you know, this, and frankly, all of the talk that we have here, we do need, while we're doing this at the level I'm doing it at, I need the protection that's being offered to hold them off while we get stronger, to hold them off while we demonstrate, look, if you divert our criminals back to us, we'll get a better result. And then maybe you're going to want to do that too, because then you can get the better result that I'm demonstrating to you, because we're doing it together. You divert here, let me work with them. And if it works, then you dismiss. And then when it works, they're going, oh, well, maybe we want to do that. You know, or even, you know, things as divergent as child support. We worked out an in-kind system if the parties agree. Now they're coming to me going, how do you set, because that really works better. And part of it is, you know, co-parenting is part of it. for child support, and all of these different things. So as you do this and they watch, you know, I mean, as a state court judge, especially in rural areas, I mean, if you start working with somebody when they're 8 years old, by the time they're in their early 30s, you're going on their third strike, you know, you don't feel like you've been like really successful here. You know, so if you look over at us and go, oh, wow, look, they took that person who was on their third strike and they haven't been in trouble in 7 years. Wait a second, maybe we should go back to that, whatever that was. Because nobody wants to sit there and do the same thing over and over and have it come back to you on Monday morning on your Monday morning calendar and go, oh my God, you have to go to prison again. That's not, it doesn't make you feel that good, frankly. It doesn't make you feel like it's working, because in fact, it's not working. You know, so we have to have a combination of our efforts in the vision. Who's going to do this part? Who's going to hold them off while we do this part? And why we reintegrate some of these people who didn't think they wanted to be integrated into our ways, but many of them are taking a second look and going, wait a minute, maybe we need to. Maybe the whole idea of being a melting pot, junking our cultures at the border, was not the most brilliant idea. You know, and maybe we should have some cross-cultural work here, because many of them had values that were very similar to ours before they came here. And so the memory is in them. And with that, I think I will end. We go back to, of course I should have remembered who we go back to, but I'm sure whoever we go back to will remember. All right.
Thank you so much to our panelists. And so if I could get all the panelists to turn their cameras on. Judge Abinanti, we had just a tad bit of fade in and out, but right now I think you're strong. So if it continues to happen, we might interrupt you and ask you to turn your camera off. We do have a picture we could put up while you're speaking, but right now it's all good. So let's have everybody turn their panels on. We're going to move into the question and answer session. Okay. And I'll toss the first one out to Lauren. Is Lauren up there? I don't see. Let me put the gallery on. Okay, there she is. Good. Okay, and if, you know, we might have time for follow-up after, but let's just go now to Lauren. And here's your question, Lauren. If the treaty negotiation restrictions that we find in federal law that prohibit Congress by statute from entering into treaty negotiation with tribes, if those were lifted, what would be the utility of treaty making for tribes today relative to decolonizing tribal justice systems?
It's so hard to envision because that door was shut arbitrarily in 1871. But I can only, you know, dare to speculate. And I'm really moved by Judge Abby's words about, you know, our obligation to place. That's still incredibly relevant. And I think we see this playing out in a lot of advocacy and battles that are taking place right now to protect and access sacred spaces. We know that so many Indigenous people are vulnerable to climate change and the damage that is being inflicted both on our homes as well as our sacred places. We also know, like, you know, the rampant violence that's taking place only in part because of the lack of territorial jurisdiction. I think there's a lot of things that need to be, you know, back on the table and renegotiated. We also know, like, you know, the Indian Claims Commission was a real ad hoc, you know, clobbered together, not even in the vision of due process and fairness that is envisioned in the Western adversarial system. You know, I would crack those open. There are so many treaties that were abrogated. That's a simple place to start. Here in California, there are numerous treaties that were negotiated and agreed upon by the tribes that were never ratified by the Senate. that's a great place to start. I think there is a lot that can be moved. And also towards Judge Abby's point, I don't think it's one-sided. I think the renegotiation fulfills all of our place, both Indian and non-Indian. And so I think the United States would be a beneficiary of re-examining treaty negotiation back with tribes. I think it's also true that there are numerous tribes, both recognized and non-recognized, that never had treaties that would also benefit, and in turn the United States would benefit from coming to the table as in a nation-to-nation FPIC type framework for a treaty negotiation.
Thank you. The next question I'll toss out to Pat. Pat, you mentioned during your presentation some of the challenges that tribes face when taking a decolonized approach to legal processes and concepts, which have been imposed by Western style courts. I want to focus on the concept of due process here. How might, and this is a two-part question, how might a tribe interpret the term due process to incorporate tribal customs and values? And the second part is, in your opinion, would this decolonized approach or interpretation render tribal court decisions vulnerable on appeal in the federal system?
So fair process, which is what I think of when I think of due process or fundamental fairness, for sure at Hopi we've defined what fundamental fairness means in a Hopi context, right? What seems fair among Hopis for Hopis in particular cases. And each tribe, I think, would have to do that in its own court system, under its own value system. That is not necessarily always going to hold up in, say, Public Law 280 states, where you've got state courts that are getting a lot of Native issues into their court systems, and they may apply comity or usually comity instead of full faith and credit to the tribal court order, where the process wasn't elaborated with exactly the same kind of procedure and notice and letting lawyers participate, etc. The most of our cases coming out of Hopi, which is not a Public Law 280 state, we don't see appeals to the federal court system. If a case gets challenged at the federal level, it's a petition for a writ of habeas corpus, right? Where we've detained somebody at Hopi and they get a lawyer and they run to federal court and they say, they've detained me unfairly. So I don't anticipate seeing a lot more of those. Even if we are interpreting due process locally. It's interesting that you asked this question in a decolonial context. We're already doing this in our Hopi court system. We're already defining these terms the way that we want to define it. One of the ideas we had years ago was to put our opinions in the Hopi language. So it has the full meaning to us in our own system. And then we translate it back out in an English version that the federal system can see, or the Western system can see. They can read their English words the way they want. We will read our Hopi words the way we understand them. And so there will be much more nuance in our internal system. I would still encourage that strategy. Do it carefully and strategically. Those are just some initial thoughts.
Thank you. Question to be tossed to Sarah. You addressed restorative justice in the context of victimization. How does the concept of holding perpetrators accountable fit within that realm? And the second part, can there be restorative justice with no imprisonment options?
Well, okay, those are big questions. So I have not, there hasn't been a whole lot of information, at least published information about restorative justice and crime victims. There has been some in the mainstream, American legal system, looking at sometimes post-conviction victim offender dialogue, things like that. So the challenge is, in this day and age, with the knowledge we have about victim blaming, right? How do we create or cultivate a conversation in a community where people blame victims for the crime that they experienced? And so people ask me all the time, well, what do those systems look like? And I said, well, some of those systems are just none of our business. You know, people are doing their thing in their way and aren't writing academic articles about it. But I think the biggest challenge that I see, if we look at domestic violence just by itself, is in many communities, you know, when there's an allegation of domestic violence, the families sort of line up in support of the victim or the perpetrator. For me, one of the hallmarks of restorative justice is an acknowledgement of harm. And when I think about acknowledgement, which is probably in my coding, the most common word that victims of crime have used is accountability. Now, what that means to one person might change, but one of them said, I just want to be believed. I don't want the perpetrator's family or relatives to continue to talk about this as though it's my problem. And so that word accountability is probably going to be the title of a chapter in my book. But how do we, in the sense that we do have people who say, oh, well, you know, you didn't cook dinner, and, you know, you stressed your husband out, and, you know, you didn't take care of your kids, and those are all the reasons that you're a victim. And that's something we want to avoid. But the hardest part is that for a lot of restorative principles, and again, I'm using a lot of literature outside the tribal context, there is a fatal flaw, and that is a fact-finding system. Fact-finding isn't really part of a restorative process. So if you have a defendant who's in complete denial that they did anything wrong, where do you start? You know, if you're somebody, I never did it, or she consented, or whatever the excuse is, and will not admit to the harm, then how does that restorative process work if there's not an agreement that harm occurred? So I think those are some of the challenges that we have. I certainly think there are ways to deal with this without incarceration, although I hear from victims all the time that they will not feel safe in their community until this person is no longer part of us, at least for a short time. So what would that look like? More in terms of thinking about incapacitation in terms of restorative or rehabilitation centers. So rather than the jail with the bars, that we talk about a system where people stay and relearn how to be part of the community through traditional, you know, medicine practices, traditional ceremonies, that it's not just throwing somebody in jail and throwing away the key. And that's what happens a lot when we talk about this. So are there ways that victims can find safety and accountability within a non-adversarial system? I really hope we can figure that out. And again, like I said, there are many places where it may be working out just fine, but we're not, you know, invited into that space. So I think that's the best way for me to answer that.
Thank you. Lauren, I want to circle back to you before I head over to Judge Abenanti. And here is your second question. You gave us a foundation for the Undrip, and you talked about the enforceability of Undrip. But I want to ask you, can you provide an example or two how tribes might utilize tribal codes as a tool to promote Undrip compliance?
Sure. Pat was so gracious in highlighting the Tribal Implementation Toolkit. The Native American Rights Fund and the University of Colorado currently have a joint project on implementing the declaration. I think most of us agree that the real implementation work is on the federal government, as well as on states. They're the ones, you know, pulling the plenary power strings, and so, you know, true implementation is on them. But tribes are not without power and authority, as well as obligations towards their own people in their own places. And so in that toolkit, Pat highlighted, wholesale adoption, but we also attempted to highlight the ways in which tribes are living and breathing human rights and indigenous rights in their code, even without using specific references to the declaration. I think there are lots of examples, but I think some noteworthy ones include the ways in which tribes have codified free, prior, and informed consent, expectations that they have when engaging with other governmental entities. Frequently, these include consultation protocols, but I think tribes have an opportunity to really dictate, here's what we expect when we're being engaged with, and this includes, helping set the stage, the agenda, and how negotiations are going to take place. There are tons of other examples, but the other example I want to highlight is the way in which some tribes have codified culture into their code. I think it's worth noting that a tribal code, just like a tribal court, is sort of a Western invention. It is a way, Western government officials introduced a code. And so it's not necessarily the best or most relevant vehicle for articulating culture. But I think it's really powerful when tribes have codified into their code their value for culture, the way in which they prioritize it, the way in their expectations for other entities for how they're going to engage with tribal culture, including confidentiality protections, an expectation for repatriation, as well as how just a general value that it is prized within the tribal system. Huge ramifications for external entities, but I also think it has a real value internally that the tribal government, even though it has a lot of Western flavors, still has obligations to uphold tribal culture. I think those are really cool. And I think they exemplify what the Declaration is calling for.
Thank you. And Judge Abernathy, I'm going to move to you and ask you this question. And thank you for sharing all the information you've already shared on the future of tribal justice systems. In your vision for the future, relative to decolonizing tribal justice systems, what is one piece of advice you want to share with everyone today?
I think that what I can give you at this point is don't forget to pray, don't forget to be kind, and don't do anything your grandmother is going to be unhappy about.
Perfect.
That would be my advice.
Perfect. Thank you all so much for being on this panel today. I don't think we have time for any more questions. I want to thank everyone for attending today's webinar, Building a Vision for the Future. I would like to now turn it over to TLPI's Executive Director, Jerry Gardner, for a few closing remarks. So we can turn our cameras off, and Jerry, you'll be on.
Okay, thank you, Kelly. And thanks very much to this incredible panel of scholars, leaders, and friends. This webinar marks the end of TLPI's three-part anniversary webinar series. If you get a chance, we encourage you to visit our 25th anniversary webpage at hometlpi.org to watch the recordings of the other previous webinars. The first webinar, Celebrating Our Journey, was moderated by Mary Catherine Nagel and featured excerpts from her play Sliver of a Full Moon, along with a panel of tribal advocates, leaders, and professionals discussing VAWA's 2013 Special Domestic Violence Criminal Jurisdiction and the journey involved there. The second webinar, Honoring Our Relatives, highlighted 5 grassroots Native organizations doing amazing work in Indian country. During the webinar, we honored these organizations and shared information about how you can help lift them up through fundraising. And we'll be following up with information about that. As we close out this series, I wanted to extend my gratitude to the, the many TLPI staff members that worked over the past year to plan these webinars and our other anniversary activities. and they're indicated here on the PowerPoint. Heather Valdez Friedman, Jessica Harjo, Bonnie Claremont, Chia Halpern Bizzo, Heather Torres, Maria Alidio, Chris Pacheco, Ashley Saraceno, Tasha Fridia, Cindy Wolasowicz, and Marlon Footracer. And a special thanks, of course, to the incredible TLPI Board of Directors, which is Judge Abby Abenanti, Dave Rash, Margaret Oberly Kelly, Ed Reyna, Pat Chika Kwaptawa, Mike Jackson, and Lucille Echohawk. And of course, happy birthday to Abby today. We also wanted to thank our co-sponsor, the American Bar Association section on civil rights and social justice. And we thank you all for joining us on this 25-year journey with us. And our growth and impact in Indian country is only possible with this community of relatives, friends, and colleagues. Thank you and have a good day. Thanks.